Let's fill out a Wisconsin prenuptial agreement together and check off every legal requirement as we go. This is Wisconsin's prenuptial agreement, the contract a couple signs before marrying to set their own financial rules. On the right is everything Wisconsin asks of it. The agreement has to be in writing, and that is the document in front of you. Start with the effective date, the day the couple plans to sign before their wedding. Type the month, day, and year here. Signing does not switch it on, it takes effect when the marriage happens. For a provision that only kicks in when the marriage ends, by dissolution or by death, the clock for enforcing it is paused until then. Next, enter each prospective spouse's name and mailing address, exactly as they will appear on the signed pages. The agreement calls them Prospective Spouse 1 and Prospective Spouse 2, names carried through the signature block and the schedules ahead. Neither person owes the other any payment or promise for this to hold. The marriage itself is the exchange. Each person has to sign it of their own free will. An agreement someone did not sign voluntarily does not hold against them. One lawyer for both, or a lawyer for one and none for the other, does not by itself make it unconscionable or change whether it holds. Further down, a clause names which state's law governs the agreement and which state's courts would hear a dispute. This is a Wisconsin agreement, so both blanks say Wisconsin. The couple can pick which law governs the agreement. The attached schedule lists each person's finances. Spouse 1's copy shows a bank account, a car, and some jewelry as examples. It can set each person's rights in any property, no matter when they got it. It can cover the right to buy, sell, use, and manage property. It can set how property is divided on separation, divorce, or death. State law sets how each person discloses what they own and owe, and what happens to the agreement if they do not. If it is challenged, state law looks at whether each person had notice of the other spouse's property and financial obligations. Spouse 2's copy follows the identical layout, with a different sample balance, vehicle, and valuable item. It can change or drop spousal support. It can require a will or a trust to carry out what the couple agreed. It can say that on either spouse's death property of either or both of them, later acquired included, passes outside probate to a person, trust, or other entity they name. Anything else can go in too, as long as it does not break public policy or a criminal law. Changing or dropping spousal support during the marriage cannot leave a spouse below necessary and adequate support, counting every source. The agreement closes with a signature line and a dated line for each spouse. Both people have to sign it, so neither page stands alone. It can be changed or canceled only by a later marital property agreement, itself a document both spouses sign. It cannot touch a child's right to support. The couple cannot sign that away or trim it. Whether the agreement is unconscionable is for the judge as a question of law, not for a jury. If it was unconscionable when it was made, that is a ground for a court to refuse to enforce it. If the couple agrees in writing to arbitrate disputes under it, that arbitration agreement holds under the state's arbitration law. Fill out your own prenuptial agreement free at FormsPal, no sign-up required.